This video is for newlyweds who have minor children. Maybe you have blended your families. Maybe this is your child together. In either scenario, this message is really important. You might think that when your spouse dies, you are going to inherit everything from your spouse, but this is probably not true. This is especially dangerous for newlyweds because a surviving spouse, in the absence of a bespoke estate plan that controls the distribution of your assets, the surviving spouse gets some of the separate property and the community property. Now, if you're newlyweds, you probably don't have much community property. So who gets the rest of the separate property? Children. And when these are minor children, you might think, well, that's okay because I'm the spouse and I will control that money for the children. I can manage it for them, but not so fast. You don't automatically get to do this. You're going to have to go through a long, drawn-out court process where a judge is going to require background checks to ensure that you are the right person for that judge to appoint to manage the assets for that child, even if it's your child. And it becomes more complicated if it is not your child. Estate planning is not something that you do only when you are very old and only when you've been married for 50 years. At my firm, we work with a lot of engaged and newlywed couples. We help them avoid unintentional disinheritance. We help them avoid these scenarios where a surviving parent, in addition to grieving and finding themselves as perhaps the sole breadwinner and the sole parent, is trapped in a seemingly endless court process to be able to manage assets on behalf of the children. My name is Patricia DeFonte, and I am the founder of DeFonte Law, where we practice estate planning with heart. You can contact us by Googling estate planning with heart. We work with clients on Zoom all over California. Learn more at estateplanningwithheart.com.